Section 10b of the Securities Exchange Act of 1934 grants the Securities and Exchange Commission broad authority to regulate manipulative and deceptive practices. The Commission adopted Rule 10b-5 in 1942 to close a gap where an individual was defrauding shareholders by purchasing their stock while hiding positive developments. The rule is divided into 3 clauses, focusing on schemes to defraud, material misstatements or omissions, and acts that operate as a fraud upon any person. Clause A prohibits the employment of any device, scheme, or artifice to defraud, targeting the overall architecture of a fraudulent transaction rather than just specific words. Clause B is the most frequently litigated provision, making it unlawful to make any untrue statement of a material fact in connection with a security transaction. Clause C captures any act, practice, or course of business which operates or would operate as a fraud or deceit upon any person. Information is material if there is a substantial likelihood that a reasonable investor would consider it important in deciding whether to buy or sell the security. Under the TSC Industries standard, the fact must significantly alter the total mix of information made available to the investing public. Projections and speculative events are assessed by balancing the probability that the event will occur against the magnitude of its potential impact on the company. Liability requires scienter, which is a mental state embracing the intent to deceive, manipulate, or defraud investors. Most federal courts hold that highly unreasonable conduct representing an extreme departure from the standards of ordinary care constitutes sufficient recklessness for scienter. The Supreme Court in Tellabs ruled that a complaint must plead facts giving rise to a strong inference of scienter that is at least as compelling as any opposing inference. The deceptive conduct must occur in connection with the purchase or sale of any security, a requirement interpreted broadly by the courts.
The blue chip stamps doctrine limits private plaintiffs to those who actually purchased or sold securities, excluding those who merely refrained from trading. Plaintiffs must demonstrate reliance on the misrepresentation, proving a causal connection between the fraud and the decision to engage in the transaction. The fraud on the market theory creates a rebuttable presumption of reliance, assuming that the market price of a stock reflects all public material misstatements. For the presumption to apply, the plaintiff must prove the market for the stock was efficient and that the misstatement was public. Defendants can rebut the presumption by showing that the misstatement did not actually affect the stock price or that the plaintiff would have traded anyway. Loss causation requires the plaintiff to prove that the defendant's deception actually caused the economic loss suffered, rather than external market factors. In Dura Pharmaceuticals, the Supreme Court clarified that merely showing an inflated purchase price is insufficient to establish loss causation. Transaction causation is distinct from loss causation, focusing on whether the fraud induced the plaintiff to enter into the trade in the first place. Rule 10b-5 is the primary vehicle for prosecuting insider trading, despite the absence of the specific term in the text of the rule. The classical theory applies when a corporate insider trades in their own company's securities using material, non-public information in breach of a fiduciary duty. Under the classical theory, the insider must either disclose the non-public information or abstain from trading to avoid violating Rule 10b-5. The misappropriation theory extends liability to individuals who trade on confidential information stolen from a source to whom they owe a duty of loyalty. In United States v. O'Hagan, the Supreme Court validated the misappropriation theory, protecting the integrity of the markets from deceptive outsiders. A tipper is liable if they provide material, non-public information to another person in breach of a duty for a personal benefit. The personal benefit can be pecuniary gain, a reputational benefit, or even the gift of information to a trading relative or friend. A tippee is liable if they trade on the information knowing or having reason to know that the information was provided in breach of a duty. The Dirk standard ensures that tippees are not liable unless the original insider source committed a breach of fiduciary duty for personal gain. Although not explicitly stated in the 1934 Act, courts have recognized an implied private right of action for victims of Rule 10b-5 violations. Private 10b-5 actions must be filed within 2 years of discovering the fraud and no later than 5 years after the actual violation.
The standard measure of damages in a private 10b-5 case is the out-of-pocket loss, calculated as the difference between the price paid and the true value. Under the Private Securities Litigation Reform Act, defendants are generally liable only for the portion of damages corresponding to their percentage of responsibility. Joint and several liability still applies to defendants who knowingly committed a violation of the securities laws. In Central Bank of Denver, the Supreme Court ruled that there is no private right of action for aiding and abetting a 10b-5 violation. Unlike private plaintiffs, the Securities and Exchange Commission can bring enforcement actions against those who aid and abet 10b-5 violations.
In Lorenzo v. SEC, the court held that those who disseminate false statements with intent can be liable as primary violators under clauses A and C. Scheme liability allows for the prosecution of individuals who engage in deceptive acts, even if they did not personally make a false statement. Following the Morrison decision, Rule 10b-5 applies primarily to transactions in securities listed on United States exchanges or domestic transactions in other securities. Manipulation refers to practices intended to mislead investors by artificially affecting market activity, such as wash sales or matched orders. While there is no general duty to disclose all material facts, a duty to update arises if a prior statement becomes misleading due to subsequent events.
The bespeaks caution doctrine may protect defendants if forward-looking statements are accompanied by meaningful cautionary language tailored to specific risks. The Private Securities Litigation Reform Act provides a statutory safe harbor for forward-looking statements that are identified and accompanied by cautionary statements. Corporate scienter can be established if the individual making the statement or senior officials authorizing it possessed the requisite state of mind. Sanctions for insider trading include disgorgement of profits, civil penalties up to 3 times the gain, and potential criminal prosecution. Companies mitigate 10b-5 risk through blackout periods and pre-clearance requirements for trades by directors and officers.
Rule 10b-5 remains the most potent tool in federal securities law for maintaining market integrity through the prohibition of deceptive and manipulative practices.